Okay, I guess we can start. It's 9. So, good morning. Welcome to everyone who's attending. My name is Riccardo Apreda, as you know. I'm a physicist, and after some years of academic research, I had a childhood friend who's an engineer. Engineering was sharing with me, contraptions and ideas for robots and stuff. So at a certain point, I decided to quit the academic life and start a business with this friend of mine. At first, we wanted to invent our own device, our own products. We did. We are still doing. But quite early, we realized that to look at other people's invention is actually, apart from being a lot of fun, it's really interesting, really important for your business, and can also help you making more money. So in these two seminars, I would like to share with you this 10 years experience in understanding how the intellectual property rights, so looking at other people's creations and inventions, can help you boost your business. In certain cases, even create your own business. So let's first have a clear definition. What are intellectual property rights? Usually people think that you have to have a very, very original idea. You have to be Elon Musk to patent some idea. Actually, intellectual property rights are the rights that are given to person over the creations of their minds. It's a very broad and general definition. It means that you can have the rights of exclusive use on many things that you create with your own mind, not just, for example, new products. We'll see in the seminar many examples of things which are maybe not always associated to things that can be protected by intellectual property rights. So as long as it's original and it comes from you, it may be the chances that it can be protected. Which rights gives you this kind of protection? The creator can use as the only legitimate users for a certain period of time. We'll see later the importance of the certain period of time and what means to be legitimate use. So I started this seminar by saying that looking at other people's invention, not just concentrating on your own, it's a good way to boost your business. So now I'll try to convince you that this is true with examples and explanations. Today, we'll talk about the general principles why IPR is important for business and what are the different types of IPR. Tomorrow, I'll show you real applications of these general principle, let's say real life applications on how you can boost your business with the proper use of IPR rights. So again, I already mentioned myself protection. So basically, when you ask the man in the street what do they think about patents or that maybe trademarks, other intellectual property rights, what they usually think of is, or can tell you what their idea of what the patents are for is this. So the common perception is that intellectual property rights are there to protect, defend what is yours, what is your idea, and let no one else use it. So it's like putting a fence around a property. This is actually true, of course, because patents protects you, and other IPRs protects you from illegitimate use, from copycats. But it's not the whole story. If we have a wider view, okay, there's still, you see here, there's still the protection and defense scope of the IPRs. But if you have a wider view, you see that all the other IPRs and all the business opportunity that can be offered to you because of your IPRs is actually a whole world to be explored and to be exploited. So first of all, you don't want to look only at your feet. You want to look at your own ideas. You want to look at everything, everyone else's ideas first. And also your idea can be protected when it must be protected. But if you're too close about it, you might actually hinder your business instead of boosting it. So these are the two principles that these slides wanted to convey you. There's a whole world out there that want to use your invention, so don't be too protective. We'll see what that means. Of course, you don't have to give it for free. And look at what other people are doing as well. So apart from the image of the tropical island, what I wanted to say is that patents and other IPRs are not just defensive tools. They're not just legal things. Many companies, and I've seen many in these years, that they think is, I mean, it's something I have to do because I have to protect my ideas, but it's a cost. I mean, they're not really realizing that it's a business tool for them. And so, and they usually do it after they have produced the inventive idea or when everything is already done, and you just have to put this legal requirement, let's say, pay this fine to the patent office so that you have protection. This is actually very limiting. I mean, it's not that it's not true, but it's only part of the story, as I said. It's a very limiting view. Actually, the whole patent corpus, not just yours, but everyone else, is a business tool. It's a goldmine of information, and we'll see many examples of that. And it's something that can be used to create value already at the early stage of the innovation process. So even if you don't even have an idea, you can already look to patents and other IPRs to get ideas, to improve your ideas, and to avoid going the wrong path as well. And then you can use your patents, your IPR rights, and all yes to create more value for your company. So it's a very well-rounded tool, not just something that you put at the end. Of course, we have seen these it's more a metaphor, no? But actually, it's not that far from reality, because studying the IPR rights is called patent mapping or patent landscaping. So it also, in the jargon of the practitioner of the community, it's a view as a word to explore. Of course, to explore an unknown land, you need a good map, and this allows you to avoid the obstacles. What are the obstacles in the sense of IPR? You don't want to infringe someone else's ideas, but if you spot an obstacle, you can also find a way around them. And again, in the IPR world, meaning that you design around the other people's IPR to create your own, which is different enough not to be in violation of them. Then you can explore new territories with a good map, which means that you can guide your research and development, avoiding obstacles, but also going into unknown land to find new opportunities to develop something new for yourself. Also, it's also a way of seeing what is the landscape. So out of the metaphor, meaning that you can see what other people are doing, you can track competitors, you can find partners, you can find clients for your products, and so on. This is called competitive intelligence or strategic intelligence. It's a real discipline. I mean, it's a lot of work done on that. And finally, last but not least, you can find the hidden treasure with a good map, which, for example, could be you can find a big partner for your startup that want to invest in you. You can license your patents. You can find new markets for your product, and so on. So there are many things. Another way to see these as a general principle is that, of course, in the modern world, in the competitive, global competitive scenario, everyone wants to innovate, because innovation is what makes you a competitive company with respect to the others. We have seen that in the recent years, I mean, all the largest and most successful company are the one that innovates. They are the digital one, like Google, Apple, and so on, but also Tesla is all based about innovation and so on. so of course it's necessary. So I would say it's necessary to innovate to remain alive. We've seen also during the COVID pandemic, who stays with the old ways of doing things, it has to be closed. But if you find, even the shop behind the corner, if it starts an e-commerce, so innovative business model, it survives. Otherwise, it might be that it just close. But innovation is not that easy. It's definitely not a linear process, because there are many obstacles. To innovate, you have to have good ideas, but you have to solve a lot of technical issues. You have to find the money to boost to sustain your innovation. There are legal possible issues. There are logistic issues, and so on. And so, if you want to pass from an idea to the real market, to sell this idea on the market, you have to solve all these problems. For many of them, and you can actually take advantage of intellectual property rights to solve or at least mitigate many of them, including the ones that are not as straightforward to think of, like the economical ones or the technical one. Of course, the legal one, it's more easy to understand. We'll see examples about that. Before going to the more detailed discussion about how to use IPR to boost your business, I would like to talk to you about two examples that have been that I have heard from Domenico Golzio, which is one of the director of the European Patent Office, which the European Patent Office is one of the most authoritative institution about intellectual property in the world. Okay, I'm enough old to remember those. Some of you might be young. I haven't used them, but you know that in the old days, let's say before DVDs and Netflix, there were cassettes also for video recording. At the time, there were two big producers. The one was Sony, and the other one was JVC. And actually, from the quality point of view, Sony was better. So its Betamax system was a better quality, but they had a very aggressive strategy for what concern intellectual property rights. Basically, they were saying no one can use the Betamax system but Sony, but us. JVC had a more open. They say, okay, yeah, I can license my technology to you. I don't mind if it's not myself who's using it, as long as you say that it's my technology, use it as a license and not just copy me and don't give me anything. This was, so again, if the common perception is that you had to protect with the patents, but actually if you don't use it, this is what Sony did. JVC did the opposite. They said, okay, take it. Of course, give me something in exchange, but take it. And what happened is that on the market, many producers of the recorder and many producers of cassettes and sets were using the VHS standard from JVC. So in the end, the market was dominated by JVC, and it was a great success, while the one who used the intellectual property right in a too strict way lost the market, basically. Another example of that, even taking things even farther, we go to audio cassette, not video cassette, so even back in time, even more back in time. Philips produced the first music cassette, and they say, okay, look, I don't even want the money as long as you keep exactly the same dimension and format. So the Philips music cassette became the standard. And also every producer and reproducer of music had to be shaped the way that the Philips music cassette was done. In this way, basically, again, Philips achieved the total domination of the market, the monopoly. Of course, it was a clever strategy to get the money afterwards and not before, not using the patents as a tool to get the money, but as a tool to get the market. And then the money came from the market. So this is, I think, a very good example of using IPR in a clever way that boosts your business, makes you the dominant leader of the market without having to use it to exclude anyone else from the market. This is one of the examples on the way you can use IPR rights to boost your business. So now we review one by one all this is general principle. Tomorrow we'll see application of that. All the ways that intellectual property rights can provide you a boost for your business. So the first things to consider is the patents and also other intellectual property rights are source and a unique source of information, of very valuable information, and not just technical one. Let's start with the technical information. So why patents are a unique source of the technical information? Because the information that is patent is very often is not contained anywhere else, can only be found in the patent corpus, which is available, free, and available to be consulted by everyone. Okay. Some studies estimated in 80% of the information is not contained elsewhere. Why it's so? One can say, well, but why people do not use the scientific papers, for example? Well, the point is that the first point is the companies do not like to disclose their secrets, right? To keep a competitive advantage. In papers, you have to tell a lot of stuff. So companies do not like to write papers usually. Patents disclose less, are required to disclose less, but if you want the protection for your idea, you need to file patents, or you're not obliged to file papers, of course, scientific papers. So basically, patents are filed by companies because they need protection, and they do not disclose everything as they should in certificate, but they still have to disclose something to have the protection. So this is one of the reasons why you find the information there and nowhere else. Also, there's the point that as we will see when I will present you the various types of IPR, you cannot, to obtain a patent, it has to be really new. So it doesn't have to be published anywhere else. So if you publish a paper or even a brochure on internet before the patent cannot be filed anymore. It's not a valid patent then, because the information there is not new. So the patents are filed first, and we'll see in the next slides, sometimes years before the products go into the market. So you find information before it is published anywhere else. Also, because sometimes this information cannot be published at all because it's not that interesting for the journal, or it's there are no, I mean, it's a finding, but there are no theoretical explanations. So it cannot be published in a journal, but for the patent, it's okay. So the first use of a patent corpus is to guide R&D, is to keep updated on the state of the art and know things that are not known in any other way. I'll show you an example of these. You know that there is an ongoing debate about if the waves from smartphones, or in general for mobile phones, can be dangerous for the brain, because of course you keep it very close to your head to talk. And you know that the the companies producing phone deny that there are dangers and so on, but actually they start to file. I don't know if you see the date of these, the year of these patents, 1998. So already in 1998, companies were already studying the effects, the potential damage to the human body of or mobile phone. You see, this is not a smartphone; it's a very old type of mobile phone. And they published patents on way to avoid it, to screen the waves not reach the brain and so on. So they were aware of the dangers, and they were already trying to produce countermeasures, but they didn't tell, at least not in 1998. So again, there are information that the company do not want to disclose, but you can still find them in the patents. And not only technical information, actually. Since patents have to, as we will see, have to have a real use in human life, have to solve a problem, you also find a lot of information about the user of certain products, what their needs, their behaviors, what are the market trends, and so on. So you can find a lot of information about the potential market for your products in the other people's patents, doing similar things to your product. And you can learn about company strategies. We will see again how to detect the strategies of your competitors or in general of the market from studying the patents. Or you can see what materials have been used, so you can plan your logistic, your supply chain, and so on. So there's a lot of information contained in patents that are, and as I said, patents are the only corpus of technical information which is also totally free and available in a centralized place. It's not scientific papers, you often have to pay a subscription, and every provider has only, not every single paper that has been published, but only certain journals, okay? Well, patents are, for example, if you go to a SpaceNet, we will see, I'll give you later on the web address, which is the European Patent Office search engine for patents. You'll find any patent that has been published in the whole world since 1800, let's say 1860, I think, for free. As I already anticipated the fact that the patents anticipate the market and actually tells you the strategies of companies in advance. Why so? Well, you can read it because patents are a cost. Actually, if you want to patent worldwide, they are a significant cost. But the point is that, so you don't want to waste your money. You file the patents only for the innovation that you consider really relevant for your company. So you have invested on that R&D, and you're planning to put that R&D into production, into a real product. Actually, this is not always true, but we'll see about that. But let's say, as a general way, real important patents covers important products for the companies. So you have, by looking at the patents, you understand the R&D strategies of your competitors far in advance, even before the product is already on the markets. And you can take countermeasure, you can do your own R&D, and so on. You can see in the second part of this slide that the anticipation of a patent with respect to the market launch can be even 25 years. Of course, this is the 2 centuries ago almost, so definitely things have changed now. We're probably closer to the 5 years of the television. In software, it actually probably does, this delay does not exist at all. You publish and the software is already the day after the software is out. But there are sectors where this is still true. For example, automotive or the patents is usually filed around 3-5 years before the products actually arrive to the market, because it depends on the cycle of the innovation cycle of the sector. So in few cases, in many cases, what you read in patents anticipate the launch in the market and let you understand the strategies of your competitor before it's too late, let's say. So when you want to use the other people's patent to guide your R&D, as you've seen, you want to keep a date on the state of the art. You want to understand what your competitors are doing. You can also study the technology as it is, don't looking at other companies, but see if the technology is already mature, so it's difficult to produce new innovation, maybe it's time to change to something else, or is stuck. If a technology is stuck, there's no advancement in the last years, maybe something you want to try to tackle so that you can do the breakthrough and be the successful one. And how to improve it if it's stuck? Well, actually, in the patents, you know what's going wrong. What is the reason of it being stuck? So you already know where to look at to find the solution. And also, you don't want to reinvent the wheel. Of course, if a solution is already there, maybe it's from 1920, and so now it's out of the rights. You can use it freely without having to spend money to develop again the same thing that is already there. So you can use the money to do something else in your R&D. Actually, this is true in positive, so you don't want to reinvent something that is there and you want to use it. And also in negative, you don't want to waste your money in inventing something that has proven to be useless or not working already. And this is another example that I got from Domenico Golzio, which I will never hand to thank for he taught me so many things about patents. This is an example about, you see, in 2000, not many years ago, a company filed a patent in the United Kingdom about a way to reduce the thermal stress of pneumatic or wheels. So it was they were really reinventing the wheel in airplanes, because at the landing, of course, the wheels get a lot of stress. Part of that is mechanical, part of that is thermal because of the friction with the land. And to dissipate this heat, they proposed to use this extension, like small vents. Actually, if they had looked at the patents, they would have not reinvented the wheel, because this exactly the same solution was already proposed in 1931, so 70 years before. If that were a good solution, they could have just looked at it and didn't spend any money on R&D to invent it. But if they discovered that in 1931 was already being invented, and actually you cannot see it in planes, that would make you wonder, maybe there is a reason why we haven't seen this solution. Actually, there were not just this patent in 1931, there were many patents with exactly the same solution since 1920. And we still did not see the solution on the wheels of the plane. So, and all these inventions were from small inventions. There were no Boeing or Airbus patenting it. And actually, if you look at the patents, you see that actually the problem is not really solved. There's a mechanical shock is not taken on. The wheel that way was too expensive and too complex to produce, because one thing is doing, you know, an homogeneous pneumatic, and one thing is creating these small channels. Also, there were other technical problems. So basically, you would have discovered that this invention is useless. You cannot make really money out of it. So you would just say, okay, good idea in principle, but it's not working, so let's move on. Sometimes companies even arrive at the products, they launch it on the market just to discover that it's not working. If they had done the research in advance, maybe they could just save a lot of money and time and reputation just by not doing it at all. This is a negative thing, but of course in positive, again, the patents there are 120 millions, and only a small fraction that is still active. All the patents that have, after 20 years, they expire, meaning they are no longer valid. Everyone can use it. Even if you don't want to use them, you still, the whole patent corpus is a database of problems, because every patent has to solve a problem and solution to problems. So you can find a lot of inspiration just by looking at that in the type of problem you want to solve. Doesn't mean that you have to solve in the exact same way. Unless, by the way, you can, of course, if it's old enough to be expired. But even if you don't copy an existing solution, you want to make your own, or you make your own, you can find a lot of inspiration in the way things are solved. Because, for example, if in totally another field, let's say you are in automotive and you're looking at agriculture, you see that a certain type of technical problem has been solved in a clever way in agriculture, then you can adapt the type of solution, not the exact solution, to automotive, and make a totally new product with a very clever idea that no one has thought before in automotive, taking inspiration for what has been done for the similar technical problem somewhere else. You can also find problems that are still to be solved and solve them. And so, because it means that they are interesting to solve, otherwise they will not be in patents, because patents are cost and are filed only blah, blah, blah. Actually, even for scientific, pure science, if you're a researcher at the university, you're maybe not interested. There is a question, how much different solutions should be to avoid patent infringement? Okay, this is a good question. We'll come to that when I will present the various types of intellectual property and specifically patents, but I can tell you already that infringement, it's complex. You might infringe something, but not something else. So in principle, you can patent something that is already existing, providing that there is a change, so not too much, not so much, but then you are dependent from the starting patent. So you still have to pay rights to it. If you want to be totally different, so not to be an infringement, but not to be dependent either, then it has to be quite different, let's say, in a sense that the way you solve the same problem has to be original and new. So it has to be not obvious and not an obvious consequence from the other people's patent. So let's say if another patent is using a nail, you cannot use a screw because it's a very natural consequence if you just have to fix things. But if you use glue instead of nails and screws, because nails and screws are a mechanical way of fixing or joining two parts. Glue is a chemical way of joining parts. So it's different enough to be patentable and not an infringement of the other. I mean, I don't know if these answer your question, but also keep in mind that infringement is or avoiding infringement is an art for legal people. It's a profession, being the patent attorney, and their job is to understand if there is an infringement or not, of course, on behalf of companies that then you go to trial and so on, or how to avoid being infringement by phrasing the things when you write a patent in the proper way. So from the technical point of view, it's not that always easy to say if there is an infringement or not, because sometimes there's a legal aspect coming into play. For the technical point of view, what I've already said, it has to be not an obvious consequence of the previous art. It has to be something that applies a different principle, combine things in a way that is not obvious. But then there might be legal tricky issues also as well. So to be totally sure that you're not avoiding, they're not infringing, you might want to ask to a patent attorney. Okay. Actually, you see here I mentioned trees. I don't know who is someone you know trees. TRIZ is a discipline. Is a Russian acronym, stands for Theory of Inventive Problem Solving. Was invented by a Russian engineer called Altshuler. He, for a period of his time, he was working at the Russian Patent Office and realized that patents basically have the same pattern of solving problems, not one pattern. He found 40 different patterns, but only those 40. He called them inventive principles. For each type of problem, there are 2-3 different inventive principles that can be used. So for example, if you, this would take another 3-4 lessons so I'm just giving you a glimpse, but to guide your R&D, you can learn this inventive principle and recognize the abstract nature of a problem, of a technical problem, saying, okay, this is the problem is that I have to divide things or to join things. What are the types of solutions that I can apply in general terms? As I said, as a mechanical solution, okay, I can put a nail, or chemical, I can put glue. Okay, which one fits with my specific problem? And then you crack the end, you turn the handle, and you find the answer. So it's a very powerful way of inventing new things by using the patterns of invention that can be found in the past inventions. The things that I mentioned before, before the question, I was saying that in patents, you find something that has not yet been explained sometimes. You find example, for example, there was a patent about radio frequency where you show some effect, which may lead to new physics or new chemistry. And the company who filed the patent were not interested in understanding why. They were only interested in exploiting the results of this effect. But the researcher can actually find this effect that has been studied by private researching companies and find a theoretical explanation, for example, for it. So it's also a source for new science. And again, it might not be found anywhere else. The example that I did before about importing from agriculture to automotive is called, it has a name because it's one thing that you can do systematically. It's called crossover. We'll see example of crossover tomorrow. And it has actually a very good way of doing business by taking advantage of what people have invented elsewhere and import it in your field. And of course, you can also discover new application. We'll see again an example of that tomorrow. Because if a solution solves a problem in a field, it may solve a similar problem in another field. So you can do the inverse of crossover. You can move to a new application and create a totally new market for you. So inspire R&D. Then there are other uses of IPRs which are more not related to the technical aspect, but to the business proper aspect. Of course, R&D leads to business, but some things are really related, and these are more related not to the technical content of patents, but to the legal nature of patents and IPRs as a way to protect or to give you exclusive right about the invention. So, of course, the first use is the defensive one we already mentioned. Is true, but it's not the only one, which is deter other people to copy your invention, your product, and keep your market share protected. But actually, as we've seen in the example of JVC and Sony or Philips, you can increase your market share using IPR. You can patent a new product, but you can buy patents from other people. You can license your patent or get license from other people's patent. Every time you license, the person who get the license will take a chunk of the market for you. Of course, he's also making money out of it, and not you directly, but he's paying royalties to you, and your product get more diffusion. So it's a way to achieve a bigger market share for your product and earning some money in the process with the royalties. Or you can use patents to lead merger and acquisition. You want to merge with a company that has an IP which is complementary to yours. So together you have a better dominance of the market. Can be you, or it depends who's bigger is acquiring or merging with whom. But still, the intellectual property rights allows you to increase the market share by putting together IPR rights, IP rights. Also, another thing that is not to be forgotten is that saying that your product is patented or is trademarked or is copyright is actually a way of promoting your image and your reputation, because it means that you are original, it means that you are cool, let's say. And there are several cases in the market where the trademark and the copyright and the patents had this positive impact on the reputation of companies. For example, you all know Elon Musk, Tesla. At the beginning, what was really interesting, now of course it's everywhere, it's in marketing, it's a good products and it's going to space. But at the beginning was really important in the company that boosted its evaluation in the stock exchange and investors, was the patent portfolio that they had. They had a huge patent portfolio on electric mobility, on batteries, and that was really the important thing. At that time was they were not selling or licensing, was only increasing their reputation, and then that led to attract investment. These are the things that you can do in positive. There are also aggressive way of using intellectual property rights. One is to mislead competitors, give them the wrong information. We have seen that there's a lot of useful information that can be found in patents because the companies disclose. But then you can use that also to cheat. You can say, okay, I'm studying these, and actually you're not, but you're filing patents. Of course, this is a strategy, it's very costly, and only the big players can do it. But this is something that helps you, that can help your business under certain condition in the competitive scenario. You can block an area or a certain solution, even if you're not producing it. You say, okay, I don't want anyone to do a certain thing. I can produce patents for all the possible variants of that product, even if I'm only producing one. by covering all the other alternatives, no one can just, so I can be the sole actor in that particular area. And there are other that we'll see in the next slide, other way of being aggressive with patents. As I said in the next slide. So you can exclude competitor from your market. You can threaten competitors. A common way the companies do that, some companies at least do that, is that they try to hide a dangerous patent for a competitor. What do I mean by hiding a patent? As I said, patents are public. Everyone can access them. So hiding does not mean to put them where they're not accessible, but write them in a way that is not straightforward to understand that they are referring to a certain product. For example, if you want to say engine, you may write device for producing motion using fuel is an engine, but it's not written engine. So if you look on Google for engine patents, you don't use the keyword that are in the patent. Nowhere in the patent is written engine. Another common example is that, for example, windscreen in the automotive, windscreen for car are sometimes filed under the category of windows, which goes into construction, into buildings. So why these strategies from companies? Because they don't want their patent to be found until then by competitors for a certain period of time. When the competitors enter in a dangerous zone for the company who has filed a hidden patent, they take the patent and say, oh, look, you are infringing these. And of course, they cannot say, I haven't seen it. Well, that's your problem. It's still a valid patent. So, and then they go to court. Of course, they reach a settlement, or they might not even go to court. Just the threat itself of a millionary suit. It could lead the competitors to come to terms with the starting company. Another strategy that is used is because of called patent bombing. You produce so many patents. Again, this is since patents are cost, this is a strategy that can only be done by big players. But you produce so many patents that the competitors just do not understand what's the real things that you're going to produce, what is the real things that is important, and they are just overwhelmed. They just give up competing with you in that specific sector. There's too many patents to be taken into account when they want to produce their own product. And as I said when I was answering the question, if a patent is not totally new, but is new at least to be patented, but is still dependent on someone else's patent, this is a strategy. If a competitor or you're as a master patent, so as a very important patent for a specific technical area, you can always file a dependent patent. So he's still the owner of the main technology, but the introduction of the new bit that makes it different from the master one, but still dependent from the new bit, might be enough to block the production of your competitors owning the master patent product, because he has not protected that bit and you did. So this is a way to go to them and try to bargain, to negotiate, because I say, look, I know I cannot do anything with my patent because it's blocked by your master patent, but still I can create you troubles because I have this bit in my dependent patent. What are we going to do? And you find a negotiation. Actually, these companies take that only as extreme measures to defend their business. There are actually the so-called non-practicing entities that make this as a strategy to make money. Sorry, I meant technical addition. The master patent says way of joining things using nails. And then this is the master patent. And then you can file a new patent, which is dependent, saying way of joining fields with nails, sorry, with screws, where the head of the screw is such that it's easy to turn with a screwdriver, okay, while the nails need a hammer. So if the actual product that is coming to market, it's easier to be used or to be produced with a screw than with a nail, and also because of the particular shape of the head of the screw that is being used, then the owner of the most right is still the one that claims the use of names, because that's the mechanical way of joining things. But the owner of the dependent patents who had this bit, so this technical addition, makes things for the product to be more successful. So if the starting company, the one with the master patent, want to use that specific improvement, he has to come to terms with the owner of the dependent patent. The company who owns the dependent patent cannot put in production that product because it will infringe the master patent. But the owner of the master patent cannot take advantage of the improvement. So it's a kind of a win-win situation if they reach a good negotiation, so that the producer of the product with the master patent can do the improvements which will increase the success on the market. But the owner of the dependent patent can get royalties out of it. So it's a kind of win-win situation. And as I said, some companies, I mean, the normal companies who produce things, produce products, produce devices, do that only in this extreme measure to not to disappear from the market or to have a good bargain, to do negotiation. There are entities called non-practicing entities. They're not interested in producing anything. They're only interested in using these mechanisms of IPR to make money by forcing the real companies, the companies producing, to pay royalties or to buy the patents because of fear of infringement, fear of legal troubles. Because as you know, in the United States, going to court for a patent infringement can cost you millions of dollars. So to avoid that, companies are usually willing to pay a fraction of their millions to the one who owns a dangerous patents. The one who do that for bad intentions, so just to get money, I wouldn't say illegally, it's legal, but let's say not fairly, from companies that are called patent trolls. Actually, these can also be used for the good. And here another example. You all know MP3, the codec for the standard codec for digital audio. Okay, the intellectual property for MP3 was owned by different actors in the market at the beginning. One was Fraunhofer Institute, but there were others. So if they didn't join an agreement, MP3 could not be produced by no one of them, because part of the technology were owned by different people. So there was a company and non-practicing entities that did something good actually for the market, because they went to each of them and say, look, you are at a stalemate, you are at a locked, but I can acquire all the IP from all of you after you give them to me, so the technology can be produced because the owner is on it's, and I give license to all of you for free. I only keep a small fee for this, you know, but so that every one of you can now produce MP3 technology, and each of you will get a share of the royalties proportional to the importance of the IPR that they have conferred to me. So they were basically making a third parties that make everyone agree, because of course within the sense they couldn't. And so everyone can produce, everyone can get their share of royalties using this mechanism. There is a question, the high cost for legal patent trials in USA is also a problem. Yes, that's exactly what I said. It costs a lot of money. Big companies can steal patents from small companies by making the small company to run out of money during the trial. What is your thought around that? Okay, no, this is definitely true. And big companies sometimes really do that. They say, okay, look, I don't care. I mean, take me to court. I will have endless money and you will not. So I don't care about. So my thoughts, of course, this is unfair, but it's happening. Around that, how can be this avoided? It's difficult. I would say it's difficult. The best way is to be, how to say, to let the big player understand that you're more valuable alive than dead, which means if they only copy you and you cannot do anything about it, they don't get all the value from you that they can get by collaborating with you and giving something back to you because of your expertise, because you can produce new patents, because this is the positive way of doing it. So you say, look, I can produce more patents if we find an agreement, and you can benefit from those patents because I know a lot. And this is actually already true even if you don't have patents. Usually startups are bought not because of what they do, but because of the people that they have. This is true in many cases. The team is what really make a small company important for a big company, rather than the patent or the product. Because the patent can be, in this way, dismissed, and the product can be copied or done in a different way, but the competence of people you cannot reproduce. So the best way to let the big player understand that it is not in their interest to copy your patent without without rewarding you. I have an example in my own company of that. Actually, we studied a device for eye surgery. I will be showing this in the slides tomorrow. For eye surgery, of course, we are very small companies, but we did this with a very important worldwide surgeon. So the competencies that went into that patent are unique. So the big player in that market, which is basically the monopolist of the market, could have said, well, I don't care about you, I'm the monopolist. But they say, okay, but you're working with that doctor, and you came out with a solution that tens of my engineers didn't come up with. So I'm not buying your patent, I'm not copying your patent, I'm funding your research. So we still got money out of it. First way. The second way to go around that is to be aggressive and say, look, I can sell the patent to someone else, which is your big player competitor, if you cause me all this trouble. Maybe it's better if you find an agreement with me. I don't want so much, while the others can. So try to create problems if they do that, if they go the way. But again, you have to rely on the fact that your patent is good, and so it has a market for someone else, for a competitor, and that you can produce other patents that you can sell to competitors, because maybe that one it's already too late. But if you can show that you can produce others, and you can go to the competitors of the big player to give them their. So in that case, maybe again, they probably prefer to use their money not to pay the court, but to pay you. It's actually probably much cheaper. Another point to be considered is this. Big players sometimes do that, sometimes they don't, because it's much cheaper to give a small company something than to pay the millions that they need in court anyway. So it's a matter of understanding the situation. The way around that is for a small companies to understanding the situation, understanding what their bargaining power is, and not to be greedy, meaning that they cannot achieve $1 billion settlement. They can only achieve something. So you have to decide what is the something that is acceptable and go for it. And not because with a big player, you cannot win if you go in a war. You can only find a peaceful solution. I hope that answers your questions. By the way, these are the all aggressive strategies. Defensive strategies in the market can be, if I find something, it's not new anymore. It's a patent subject. Or if I can also publish a scientific paper. So in that way, I avoided that other people can patent that. For example, if I fear, coming back to the example of the big player and the small player, if I fear that the big player will make a patent that exclude me from the market, I can patent it or even publish a scientific paper that basically makes impossible for the big player to protect their product, so they can keep doing it, and he cannot take me to court with $1 million judgment against me, because the information is public. Of course, I've lost the exclusivity, but I would have lost it anyway, because I cannot compete with the big player. So at least I can have my niche where I can operate without anyone taking me to court. This is another possible way of doing it. Of course, it's not the most desirable one, because you cannot, then you don't have any patent to protect you. But also, as I said, we spoke about the master patent. We can also spoke about pioneer patents. Pioneer patents are the one that open a new area. Then it means that, of course, there will be research to improve the product. So there will be other innovations. So what you usually want to do is to, if you are lucky enough to have a pioneer patents, then you have to protect it from variation, from innovation, incremental innovation. So you also want to put other patents to create a fence around it. Okay, so far we've seen research and development guidance with the IP. We have seen how to get a bigger market share. Now let's see how to attract money, investments. So the first way of doing it is, we already mentioned, is using patents, license your patents, even to big players, and to get revenues out of it. Also going back to the question before, again, if you are a good team, research, getting a license of your patents might be much cheaper for the big player than either reinventing your solution, either taking you to court. So if you are not greedy, you ask a reasonable price for licensing your patents, probably it's already done. I mean, the big players do not have any interest in destroying you, if it's cheap enough, let's say. But in general, apart from big versus small, if you license your patents, is a way of getting money, is basically doing nothing. You don't have to produce yourself But another way to do it is to cross-license. You can say, okay, I have this, I protect this innovation, you protect that one. Let's exchange license so we can both produce a better product and go ahead of our competitors. And of course, I won't be alone, we will be two of us, but at least we get better than the other 10 in the market. So cross-license is also, having a patent is a way to foster the possibility to cross-license, to increase your IP, total IP by cross-licensing. The example of MP3 that I did before is the one when you aggregate multiple actors using a third parties, but you can do directly with a business partner, let's say. There's no longer a competitor, it becomes a business partner. And this, of course, is also partnership with joint ventures. This again connects to the example big versus small. IPR is not just the legal part, but it's also proof that you are good at what you're doing. Because if you're good enough to have something which is original, it can be patented, it means that you're good in the technical way, right? So sometimes the partnership, the joint ventures are not because of the cross-license, or maybe this is only part of it, but because of the teams that are behind the IPR. So you say, okay, let's make something together because we have proven that we are good, and you can see the patents as proof. Also, having patents improve the negotiation position, your negotiating position. For example, as I said, if there is a master patent and you are in danger, but then you can try to negotiate a better position because of your, or when, for example, and I now skip to the last point, let's say that you are going to be acquired, you have a startup is going to be acquired. Well, your valuation is definitely much higher if you have an intellectual property than if you don't. The same in mergers and acquisition. In mergers, this was a case of acquisition. The two companies are almost the same size, but one has more intellectual property. Of course, they will get a bigger share of the merging company because it's the value. It's also evaluated using the immaterial asset, the intellectual assets, not just the products or the factory and so on. And last but not least, these other two points. With patents is much easier. I mean, it's not straightforward, but it's definitely easier if you have patents than if you don't, to attract investment, both from private investors like venture capitalists, and from standard sources like banks. If you want a loan from a bank to boost your research and development, and you have a patent to protect the result of that research and development, it's easier to obtain the loan. And the same with the venture capitalists. If you have a startup, you have a business, whatever, and you're going to find investors, if you have one or better, a large patent portfolio, remember the case of Elon Musk and Tesla, then it's much easier to get investment, because the investor feels that the risk of their investment is much lower, because there is a legal document or a set of legal documents protecting their investment when it comes to the market. Fourth way of using IPR to boost your business is to understand the future development of a field, of a sector. And in the future and present. Present is against the competitors, so you can make a strategy to avoid doing the same direction of competitors, or to go in the same if you want, but at least knowing what they are doing. You can find partners for development and market opportunities. We'll see example of that, of course, in the next slide and tomorrow. So you can create a better present, so because you are aware what the other competitors are doing, and you can find partners and business opportunities. But you can also try to understand the future, this is a discipline called foresight, or technology foresight. There is a question. Can you please enable the raise hand option so that we can ask our question easier? Of course. Sorry if I didn't. Actually, I don't know how to enable the raise a hand thing. I'm asking the HiPEAC support if they can allow that. Sorry, I don't know how to do it myself, so I'm not familiar with Zoom that much. So if the support can help us, otherwise I'm sorry, I just keep going this way. And there's also another chat. 1 minute. Okay, perfect. Thank you very much. Thank you very much for doing it. Okay, thanks. So feel free to raise your hand then. Foresight is a discipline. And again, it would be probably other 2 or 3 lessons only to speak about foresight, but we'll see examples tomorrow. Try to understand how the technology will evolve in the future, and patents are the best source of information for doing that, to understand how the technology will evolve, because in the foresight you detect development patterns which are very characteristic, they've been studied. We'll see example of what that means. So it's possible to see, okay, if I am at this stage of the pattern, I know that in the next years we will follow the same pattern in this way. So you can foresee what's coming up next in the technology in your field. You can understand what are the advantages and disadvantages of your technology, and so what will change. Of course, the disadvantages will have to be overcome, and so on. And in general, you can understand the trends, both market-wise and technological-wise. This way, with 5 years anticipation, more or less, you are able to understand what will happen in 5 years and take measures accordingly. Of course, not always like that, but we will see real case example of companies we worked with my company at Quadro, that in advance, sometimes 5, 6 years in advance, we told them what were going to happen. Sometimes they listened to us, sometimes they didn't, and then actually it happened. And those who didn't listen to the warnings that patents gave them, of course, had a failure on the market. For now, just take them as for granted, but I'll show you a real example of that. So again, with patents and intellectual property in general, you can also try to understand foresee the future. Of course, it's not the magic ball. It might be wrong and it doesn't tell you everything, but still, it's a very powerful tool for understanding what your strategy should be. And okay, these are the 4 main ways in which you can take advantage of intellectual properties. One is guide R&D. One is navigate the market and the competition. One is attract investment and money and growth in general. And the 4th is inform your strategy for the present and for the future. All of that I put a slide specifically for startups. I know that these whole cycle of seminar of the school, this summer school, as a focus on entrepreneurship, but for people coming from different parts of life, but mainly from academia and research. So it is likely that entrepreneurship plus researcher might lead to startups. So I thought that taking all the 4 general direction, making a slide specifically for startups could have been a good thing. As I said, for any type of company, patents are important for reputation and promotion. But let's say that Apple does not need it that much anymore. Although it has one of the largest patent portfolio in the world, so it's still important for them. But in the competition, for the users, so reputation promotion is not very important. But for startup, it is. A startup who can claim it has one or more registered rights, which can be patents, trademarks. We'll see about that in the next slides. It's a better reputation. Actually, sometimes since it's a startup, so the product is not already on the market. The people in the startup have not proven themselves successful yet. Sometimes the only objective parameter that can be used to value a startup, for example, from an investor, is the presence of a patent, because it's an objective asset. While the product is not there, the team, okay, it's good, but you know, it's difficult. It's not an objective valuation. And as I said, patents attract investments. We'll see an example, a real life example tomorrow of a company that got a $2 million investment when they had the patents, and that they were refused before having the same. I mean, the product was already there, was the same. Before the patents, no one listened to them. After the patents, they got $2 million investment. Why? Because the risk for the investor is much lower. And as you know, all investors, the first things that they value is the risk of their investment not coming back. Or at least one of the first things that they take into consideration. And of course, the more you have the more patents you have, and the broader the coverage that allows your startup to have a competitive advantage with others, the better. Okay, skip the last point. The point is, of course, if there's too many patents in the same sector, is not good for you, because your technology is not unique anymore. Okay, so I hope that this concludes the first part of today's lectures. I hope that I have convinced you that IPR are good for business, and not just as a legal tool to protect, but it's also a way to boost your business by attracting investment, understand your strategy, finding partners, blah, blah, blah. And so it's worth studying, worth using, worth producing if you can. I'll pause now for 5 minutes just to give everyone some time to relax. And I will, in the next hour, I will show you all the different types of IPRs. As I said in the first slide, this one, any creation of the human mind is more or less protected by a certain form of IPR. This allows you to play a lot and to create a lot of value for your company if you use all the tools that the general IPR discipline gives to you. Not just patents. I talked a lot about patents because, of course, they are important and I work with them a lot, but they are not the only tools, especially when it comes, for example, to software. We'll see in the next hour. I know that many of you come from the ICT world. So software is trickier than devices, let's say, for many reasons. And patents are not always the best or the only way to protect software, for example. So it's a complex thing. It's better to know all the ways you can all the tools that you can use to create these value for your business using IPRs, not only patents or not only trademarks, for example. So I stop now for 5 minutes or even less. And then we go through the different types and understand what are the advantages and disadvantages of each of them. I will not go into the technical legal aspects. I will concentrate on what's useful for the business for each of them. Okay, see you in 2-3 minutes. Okay, I'll give you one minute for the people who are doing things to reconnect, and then I'll start again. Yes, raise the hand.
Hello, can you hear me?
Yes.
Okay, perfect. It's Arya from TU Darmstadt in Germany. I have this generic question. I don't know how precise it is and I can answer, but I have this generic question about if two companies doing the same thing, like trying to solve the same solution. For example, we have Uber and Lyft. They are trying to address the same problem, having this taxis that, for example, can serve many different people using a single app, for example. How come they do not come into this patent infringement? They both have a couple of different patents. So how come they don't get into a fight?
Okay, actually, they might get into the fights and you just don't know it, but not because you, because no one in the public knows. Okay, there are two things to consider. First of all, Uber business in itself might not be patentable, because just calling a taxi from a mobile phone is not new, okay? So the fact that two companies are doing the same thing, which is already known since a century, because a phone call to taxis have been there for a century, this part cannot be patented. So they're not infringing each other because there's no patent at all owned by them. So the fact that they're in the same business, if the business is there since centuries, or since at least 20 years, because 20 is the limit validity of a patent, it's not a problem in itself. What they can have patented are some specific technical trick that they did to improve the booking system or the reward of drivers. Okay, in this they had to be different, but this does not mean that Uber cannot do taxi booking, you know. It's just that it has to do in a particular way for specific things like, I don't know, the app must have 3 buttons instead of 2. So as long as they don't make it exactly the same way, they can do the same business. Otherwise, I mean, that could not happen. Think of Apple and Samsung, or any phone. I mean, making phone calls is available to every company because it's been there for a century at least. Okay, but Apple has done the shape of this angle different from Samsung. So as long as they have a different shape, they can still produce phone. So this in general means that the infringement is there only if you do exactly the same technical solution. So as long as you do the same thing but with 2 different solutions, it's fine. Second things that I told you is actually they might get into fight, and they do. It's just that usually these things are not known to the public. But they fight about these kind of things. By the way, there's a funny anecdote. Do you know that they actually, no, remember who sued you, who sued who, but they tried to say that the tablet is not an, I mean, the first to produce a tablet was the Apple with the iPad, and they were suing another company, I remember it was a Samsung, for the imitation, the tablet, not the iPad. But then the attorney of the sued company managed to demonstrate that the concept of a tablet was there since 1979, something like that, and so it was not new. And so Apple could not claim infringement of the iPad concept against their competitor. And you know why it was there since 1976, 79, I don't remember? Because it appeared in a Star Trek episode that one of the characters was using a tablet. Of course, there was not the technology to make it work, but it was there, the concept. So the tablet is not a new invention. But what can still be done, and it has been done, the way I think this reached the news, there were billions-dollar outcome of the trial for specific technical things, like, for example, I don't know, the touch screen or the battery life. So these kind of technical things can be protected by patents and are actually used one against each other. But sometimes, many times, these are settled outside court because many of these big companies are in the stock exchange. And it wouldn't be very good to know that they are spending all these millions in legal issues for their valuation in the stock exchange. So for them, it's usually easier to settle down their disputes, finding an agreement, than going public or going all the way to a bad judgment against one of them. Because even if the one who wins will get troubles in the long run. Also because, as I said, the big companies usually have patents. I mean, Uber and Lynx, they might have patents that block each other. So if they go to a legal war, both of them will have to lose something, because Lynx may be an infringement of a patent A, and then Uber can be infringement of patent B, and so on. So when you go into legal troubles, it never ends, and it's a waste of money. And if you can avoid that by reaching an agreement, it's usually better for the big companies. So what I would say is that sometimes they really fight. Sometimes it's not an issue because they are doing things differently enough. Sometimes an issue and they do fight to the death. It happens sometimes, and when it happens, it's it's $1 million or $1 billion. And I'll show you example of that. For example, there is an infringement suit on a motorcycle that it's in the next slides. Sometimes they do fight only up to a point, and then they reach an agreement. And usually these are not known to the public.
Okay, thanks for the explanation. Just one more small question, which is related to the previous question. So let's assume that, for example, Uber has this patent filed for selecting the best drivers for a customer.
Yeah. And
Lyft would like to do the same thing. So they would like to find the best driver. So these are technical things that both companies need to do in order to fulfill the requirements or reach their goals. So if they want to patent the same problem,
you don't patent the problem, you patent the solution. So the problem can be the same as long as the solution are different.
Okay, but it means that the title of the pattern would be the same thing.
The title is not a problem because what make a difference in we will see when I will show the slides about patents is the claim. Patents have a very rigid structure like scientific papers, title, abstract, and the important things from the legal point of view is things called claim. If it's in the claim, has a legal value. If it's in the title, doesn't matter. So the title can be exactly the same, the problem can be exactly the same. What is important is what it is claimed to be the solution has to be different. So if the problem is find the best driver for how to find the best driver, if Uber do that with an algorithm that they use Wikipedia to study, and Lyft do it with an algorithm that study moon phases, it's fine. Of course, if they do it in the same way, then no. Then one of the two is not a valid patent because the other one came first.
Okay, got it. Thank you. Thanks.
Yeah, well. Okay. I'm still sharing, right? See, okay. Okay. Intellectual property is not very useful, just very useful, is actually everywhere, much more diffuse than you can think at first, at least. Of course, if you think then you understand that it's true. But so let's take the example of a Vespa. I'm from Italy, so and actually very close to where the Vespa is produced. So this for me is a part of the intellect. So idea can be a different form. It can be a technical idea, and you get a patent. This is a drawing from patent. But you can be a shape, a design, an aesthetical thing. It can be, for example, these are is a shape of the Vespa. It's a unique shape. It can be protected. It can be a name, a slogan, and so you get the trademarks. So Vespa itself. Vespa is a common word, but it's applied to a scooter, means something, it's evocative, so it's something that can be protected. It's original, it's creative, it can be protected. But it can be any type of creation. For example, if I make a movie out of it, of course, this can be protected by copyright, as you know. So basically, as I said in the first slide, any creation of human mind can be protected. Of course, there are limitations because you cannot protect everything, but many things, and not just technical one, not just art can be protected, but not just art. Basically, anything that you produce that is original enough, is creative enough, can be protected. And so this gives you a lot of tools to play with. So let's go a bit more in the detail with following the example of the Vespa. So if it's a technical idea, so an invention, let's say, you have two different types. We'll see the difference in a short while of protecting it. One is the patent, the invention patent, and one is the utility model. If it's the appearance, the aesthetical, you have two, you have basically, well, they are more or less the same thing, industrial design or design patent, they're also called. Then you have the name or the logo and so on. So everything that connotates the identity, the brand. You have trademark and trade names. And for everything else that is not, that does not fall in those three categories, but is still related to creation, it's copyright. And as you've seen, I also put software. We'll come to that when we speak about copyright. Then there is actually a variety. So one is very important, is trade secret. This is something that at first when I saw it, I thought it was very strange. I mean, a secret is a right. So what you don't want to patent is still protected by the law, if there are some conditions, and we'll see them. But you can also, in certain legislation, certain nation, you can also patent variety of plants, of vegetables. And in the European Union, this is important for ICT, you can also protect databases. This is, again, something that many people do not know. They only think of patents to protect technical ideas. There are other ways to do it. One is copyright, one is database, if it's a database, and so on. So there are alongside these four ones, which are the major ones, and trade secrets, which is kind of a strange because you don't have any document. These are all documents, they are all registered. While trade secret is nowhere because it's secret and still is protected. And then you have other minor rights which are also very useful to be known. As I said, there are many, and they have different in use, in regulations, they protect something in a different way. So what is really important is you want to make the best use of it, to use them in combination, not that just stick to patents or to trade. You want to do both to create the most value for your company. Now we will review them one by one. As I said, I will not go into the technical details. I only try to let you understand what are the differences, how can they be used to boost your business. So first one, let's go first to the design patents. So the appearance, the aesthetic of the products. You can read the definition. So the activity, blah, 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 formal or ornamental appearance. So it's aesthetic. Doesn't have to be, it does not have to be technical. It has to be a mass-produced item, so it's something that have a commercial value. You can, otherwise it's copyright because it's a work of art. So artisans cannot, let's say, achieve a design patent. It has to be reproduced in exactly the same way. But of course, it has to be a function, aesthetic function, to appeal visually to potentially consumers. Sorry. Again, the fact that it has to be sold is also important because otherwise, again, it's art. Example can be anything of two dimensionals like patterns, lines, color, three-dimensional shapes, can be patterns in textile, in clothes, can be the overall design of car, can be, so as long as it has an ornamental and aesthetic value and it makes it distinguishable from competitors, appearance and ornaments, they are important. And another interesting thing is this, they have to appeal the eye and not have a technical function. There are only a few exceptions to that. One is Lego. You know that one of the trick of Lego is the fact that the two bricks connect because in the hollow part there are actually some studs. So to make a better, a tighter grip between the two bricks. Okay, this is shape, so it's an ornamental. It actually has a technical function, but the patents for the technical function has expired already. So Lego tried to have it covered by a design patent, which is a different type, so it doesn't apply with the same time limit, blah, 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 because it's also shape, which incidentally is also a technical advantage, but it's also ornamental, right? It looks nicer, and it's recognizable by the users, by the customers. Now we see an example. Okay, first, before going to the example, I promised you about a big war in the scooter world. Criteria for registration. It has to be new, so the shape does not have to be, or the pattern does not have to be anywhere else. It has to be original. It cannot be just the reproduction of something. An individual character, meaning that it has to give your product something that differentiates it from others. And the infringement is made if in design, if you basically produce it, import it, or even just sell or hire. I mean, you can also hire the product with the same design without the consent of the owner or the legitimate owner. The copyright lasts 25 years, so 5 years more than the patents. So this is one of the reasons why Lego wanted to extend this protection from competitors. These two are two scooters. You can see that they are almost identical, not totally identical. For example, you see at the wheel there is a different mechanism for the springs and so on. But if you look them far, there are so many similarities. You know which one is the copy and which one is the original? Okay, the bottom one is the original one from Piaggio. is a Vespa. Is one of the many designs that are coming over the years for Piaggio scooters. And the above one is a Chinese copycat. And I put this example specifically because only 2 weeks ago there was a sentence from the European court saying that this is in infringement with respect to the original one. So this is a case when the war really happens. There is a big company and another big company, a Chinese producer and an Italian producer, competing in the European market. And there was a design patent that has been used successfully in this case to stop completely the import in Europe of this product, guaranteeing exclusivity for. And this is not based on patents, but on design. Because in the case of a scooter, what makes a real difference is not, well, might be the, the engine and so on, but nowadays is more about the aesthetics. People choose a scooter because it looks nice or because it's a, of the imagery that it comes with it. Another type of intellectual property, which is very important and sometimes is overlooked by people, is trademark. Trademark, again, can be, there's a lot of possibilities for trademark. In general, is a distinctive sign that is used to identify either a business or the organization running the business. It can be words, it can be numbers, it can be, of course, in combination with words, it can be devices, for example, gadgets or drawings and or logos that have three-dimensional shapes. Can be a combination of all of them. It can be a logo with the numbers and blah, blah, blah. Can be colored or white, black and white. Words themselves can be in graphical form or as word. So just the word itself is a Vespa. I don't need to write in a certain way to be protected. Vespa for automotive, it's a trademark and I cannot use it. Can be three-dimensional. For example, the Mercedes sign is a three-dimensional. So it's a, as I said, the logo tried to trademark also the shape of bricks, but this did because they did it successfully with the design patent. They also tried to use the three-dimensional natural trademark to also get a trademark, which has a much longer duration, but this time it was not successful. They said, no, trademark doesn't apply. It can be not just visually, or it can be audible sound, they're called sound marks. For example, if a certain tone of the Nokia tone, for example, it's identify specifically the company, then it can be trademarked. It's as a sound mark. Can be olfactory marks. So even a smell can be trademarked if it allows you to distinguish your product and your company from others. For example, a certain fragrance could be so recognizable that the customers can tell that is a product of your product, then this can be trademarked. Can be other, for example, things that can be touched, even if you don't see them, and so on. So it's a very broad protection. Another important distinction is between the two symbols, TM and the R in the circle. Actually, the only one that tells you that you really have the protection is the registered trademark. They are within the circle, because it means that you have really registered that name, that logo with a governmental agency in a country. So it's really protected by the law. The trademark, the TM, is actually means that it's not registered, but you're still claiming the rights. These, in certain jurisdiction where there is the common law, meaning the Anglo-Saxon country mainly, you still get some protection. In Europe, where usually there's no common law in many countries of Europe, this is not true. You have to register it to get the full protection. But in many countries, you still get some protection if you put the TM. It means that you have not registered it, but you are saying that it's something distinctive. So people should not copy it in any case. So you still have the possibility to take them into court, even if you don't register, you don't pay the fees for registering in any office. You just need to put the TM. So when you read the website, you will see a lot of TMs, especially in the United States, because basically it has no costs, but still gives you some protection and some reputation, because you're claiming that it's original. But nobody has really checked that it's really original. Nobody has issued any documents that it is not registered. Still interesting to know, I would say. It has, okay, to be registered, it has to have a distinctive character. It can be represented graphically. This is not always true because it can be a smell, depending. And has to distinguish your goods and services from competitors, from the others people. What cannot be trademarked? generic names for your sector. For example, Apple cannot be used for trademarking apples if you're selling fruit, because then it will block anyone else. No one can sell apples but you. This is an unfair competition. Of course, this does not apply if Apple is using in a different sector than fruits. So it does not have to be a generic term for the sector. No, it cannot cause confusion or deceive the customer. So it cannot be too similar. For example, when I was a child, there were the Clarks. It was a brand of shoes. It was written with the KS. There were some copycat with the Clarks with an X. Of course, this is deceiving the customer. Okay, this is cheating. So these are not allowed. Cannot be registered. It is more or less the same. Cannot be identical or deceptively similar to registered trademark. And then the other two, of course, are if, of course, it's a scandalous or contrary to the law, it cannot be trademarked. But this is usually not the case. So what are good trademarks? I think you want to give a name, a brand name to your new ideas, your new startups. So strong trademarks are suggestive trademarks. For example, Jaguar for the automobile, because it tells you, it's suggestive in the sense that it tells you that you can imagine power associated to the animal, and then you transfer it to the automobile. Can be arbitrary. So they do not have any relationship with the while Jaguar has a suggestive connection to the automobile, to the cars. Apple and computers do not have any connection. So this is also very strong and good trademark. Or can be fanciful, meaning they don't mean anything. Kodak has no meaning, but it's a nice and to associate to the product, right? So if you try to avoid very generic, very descriptive way of, for example, if you want to trademark a software that does sorting of web pages, do not call in web page sorter. This is sometimes might not be even registered because it's too generic, but even if it is not a very strong mark. Call it Zippo, whatever, or Eagle, something that is either suggestive, arbitrary, or fanciful. Another things that is interesting to know is that the trademarks can be renewed forever, so they do not expire. The only occurrence in which a trademark can expire is because it becomes too commonly used, so in a sense it's a victim of its own success, to become a generic term. For example, aspirin. Aspirin is actually acetyl salicylic acid, so it's a chemical. Aspirin is the brand, sorry, is the commercial name that was done by the first producer. But now everyone do not use acetyl salicylic acid because it's too long, and so they just say aspirin, meaning, but it can be produced by anyone else, not just by the original owner. So aspirin now is a generic term for that chemical drug, and it cannot be used as anymore as a trademark. So the original owner cannot claim infringement or royalties on the use of aspirin. And the same for all the things that you see, Thermos, Vaseline, Frisbee. I didn't even know, for example, that Frisbee was not the common name, but originally was the trademark name. Linoleum, I always thought was the name of the substance. But again, the violation can be infringement and counterfeiting. Infringement is if you try to register something that has already been registered, and counterfeiting if you try to produce something that is too similar to what is to the trademark. Okay, now I promised you that I wouldn't go too much into the details, but tell you why using this for business. With the design, we're seeing, because protecting the design sometimes is more important than protecting the technical things. Another example comes from the mobile phone and the tablets. Some of the millionary cases that go to court for mobile phones are not related to technical stuff, but to design stuff. For example, the shape of the corner of a mobile phone. There are tens, if not hundreds, of design patents on the corners of mobile phones, which is strange if you think of it. But now the war is on these details, because the customer do not choose usually only with technical, but mainly because of aesthetical and other aspects. So design patents are very useful. Sometimes they're very important. And if you can combine design patents and technical patents, it's better for your product. Trademarks are another case which are very important to be considered because, first of all, they are very cheap compared to patents. Take into account that extending your patents in many countries to have a protection in all of Europe is quite costly. Trademarks, it's much cheaper in this respect. And it's easier to enforce because to prove that the patents of your competitor is infringing or violating your patents takes a lot of technical expertise. They have to have a patent attorney for blah, blah, blah. Trademarks are easier. You just have to look at them and say, no, this is too easy, too similar. So it's very easy to enforce. And trademarks are very visible, while patents can protect aspects of the product which are inside the product, so they are not manifest. You would have to open the product to understand that there is a violation. While trademarks are there, you see it immediately. Also, since they are the most visible and recognizable ones, they create the most immaterial asset for your company. I'm not saying that patents are not important. I mean, we've seen that they attract investment and so on. But if you also have a trademark, that it's make you a uniquely recognizable in the market. So it's very important. It can become, in certain conditions, one of the most, if not the most relevant of the intangible assets that you can have. Two examples. When Diamond Foods bought the Kettle Foods, which was producing potato chip, the purchase price was $235 million. And it is estimated, I mean, it's not estimated, it was in the contract, that 40% of that purchase price was considered the intangible asset of Kettle Food as a trademark itself. So the brand, the people that were the customers of Kettle Food were linked to the brand. They liked the brand. So selling the brand was even more valuable than selling the factories or the recipe for the potato chips, because the customer were buying that particular brand. Another example is that, for example, Apple brand value. I look at on the statistics, and is $200 billion. That for the brand only. While if you look at the market capitalization is, of course, in the order of trillions, but still you see that a considerable chunk of it is given by the brand, the Apple brand itself, not just by all the technical aspect of the computers and the iPad and the iPhones. Okay, now let's move to copyright. Copyright literally is the right to copy. So it's the exclusive legal right that is given to a creator to copy, which means reproduce, distribute in any way, print, publish, display, perform, film, record their creation. Also to create modification, this is very important for software, we'll come to that, and to be recognized as the author. Okay, so it's a right to copy, but actually also to make variants and to be recognized as the author. Basically, copyright is the widest of all, because it covers literally all forms of communication. Can be literary works, can be words, written or oral, can be music, can be artistic works, can be map. Of course, I've lighted the one that are probably more relevant for the technical world, because many of you would be also artists, but I assume that all of you are in the technical world. Right? So maps and technical drawings can be copyrighted, motion, jewelry, furniture, curves, and computer programs. They can be copyrighted either as literary work because they are in written form, or independently as computer programs. We'll come to that because it's important, of course, in a moment. And also databases can get copyrighted, which is actually called database right. It's a separate, it seems very similar to copyright, but it's a separate one. Another important things to consider because we are coming to software is that the copyright law protects only the form of expression of the ideas, not the ideas themselves. And this has a relevant implication for software. Because why copyright so? Because of course you don't want to block the creativity of all people. So if I make a poem about the sadness of life, the only thing that I can protect is the specific form of my poem, not the idea of making a poem about the sadness of life, because this will prevent other poets to make their own creations. Okay, when it comes to software, sorry, just a second. See, when it comes to software, I don't have a slide, so I'll speak about that now. There's two things, the form of expression and the created derivatives problem. They are two separate issues. And okay, by law, software can be protected by copyright, and in many jurisdictions cannot be protected with patents. But in all of them can be protected by copyrights. So filing a patent for a software when it's possible is always a good thing, but also filing for copyright is better because it gives you additional coverage. It's sometimes the only coverage. But, and here is the but, the problem is they only protect the form of expression of your code, not what the code does with the copyright. Which means, as you know, better than me probably, that if I write something in Java with the two nested cycles, and then I write a program in Python that does exactly the same thing, but with a different language program and 3 nested cycles instead of 2, it's exactly the same thing, but it's from what concerns copyrights is different. So filing a copyright for a software used in the past did not give you enough protection because it was always possible to rewrite the program in a slightly different way, and then the copyright did not protect you from the form of expression. Luckily, because it's too different from expression for even the idea is the same. Luckily, recently, since of the importance of software and protecting software, the legislation is when the legislation is not changed, but let's say when in the court the judge has to interpret the legislation, it's taking more and more into account the fact that created derivatives is also a right protected by copyright. So if you write a software and someone modify it in the form, but in a way that this can be considered a derivative of your work because it does the same thing, then the judge may be in your favor using these other aspects, the created derivative. So the lesson is, up to 10 years ago, you probably filing copyright would be almost useless because you don't get enough protection against the variants. Nowadays, things have changed. So nowadays, if you want to protect a software, it's better. The best is to have also a patent, but for sure, it's also good to have a copyright. So you just go to the copyright office of your country and you say, I want to and in this software. It's not mathematical, it's not 100% sure that you will, you can use that successfully, you can win, but you can at least cause a lot of troubles to the people who's copying your software. Because now the things are changing and there's a more and more desire to protect also software producers. Okay. Another thing, okay, few other things that are relevant for copyright is that it's actually automatic. Even if you don't register it, copyright, there is a difference. Trademark, you need to register it, otherwise you have to put STM, but it's not the same. Copyright is automatic. Even if you don't not register it, you can claim that it's, as long as it's written and recorded. So it's always better to, there is a question. The general understanding is that we cannot copyright a software code. No, you can. That's what I said. You can copyright a software code. Also, since database can be copyrighted in EU, does it mean we can copyright an AI algorithm that has been developed based on a... Yes, you can. Okay. You can copyright a software code, and there are ways to also to patent it. Also in the European Union, we'll come to that. So you can get protection in 2 ways. For the database can be copyrighted in the European Union, and you can copyright the database on which the AI algorithm is based. You cannot copyright the algorithm because of the database. But you can copyright the algorithm itself because software programs can receive copyright. And under certain conditions, they can also receive a patent. So basically, your AI algorithm that has been developed based on a particular database can be protected in 3 ways. You protect the database itself with a database right. You copyright the algorithm, and you try to patent the algorithm. I hope that answers your question. For the patents, we'll come to that. Does copyright protect the source code, the binary code, or both? both because it's written, both because you can deposit in the Copyright Office both codes, as long as if it's written and so can be recorded and stored in the it can be protected. So you can it's two different yeah, okay. Going back to the okay, as I said, the using the C within the circle is like the R within the circle for trademarks. In this case, it's not necessary, but why you want to put that? Because it will improve your position, because the infringer cannot claim that he didn't know. And so it will get a heavier fine, heavier negative result from the trial, because if you put the copyright mark, it's clear that you have been original and creative. By the way, I don't know how many of you have noticed that in my slides, I put somewhere the copyright trademark and somewhere I did not. Specifically, all the first part had the copyright by my company for this year, apart from the example that I got from someone else. And then I stopped to put the copyright afterwards. Have you noticed it? And if so, have you wondered why? Well, I guess by now I hope the answer is very easy, because the first part, it's my original elaboration, at least in this form, because of course many of the information are not a secret or something that I come up with. But the way I shaped these slides, it's my creation. So I wanted to protect it. Also as an example to you, not because I don't trust you, of course. So I put copyright. Where I did not put is because this example is not mine, and I credited the owner of the example. I don't know if he has claimed copyright for it, so I could not put the copyright sign on him. But this, since it's automatic, I don't need to. I just have to recognize him as the author, which is one of the other rights of the copyright. So the author of this slide in the original idea and the original form is Domenico Golzio. I'm not claiming any right on them. I'm just reproposing them. This one is my elaboration on concepts that are known, so I put the copyright. And these other ones, especially these, are basically, apart from, okay, there are a few things that I put them myself, like the examples, but these are basically taken, almost cut and paste, they are a bit rearranged from the legislation. So I cannot for sure claim copyright, not even in the form, because the form is almost identical to the original one. So, of course, this is I put them mainly as an example, but for your work, try to understand what is important to protect and what is you cannot claim that you're protecting. Okay, copyright lasts for 70 years after your death, the death of the author. So again, it's very important to have copyright because it lasts much more than patents, if you can. But of course, it has to be original. Okay, of this other slide, you just have making derivative works. So infringement is also, apart from reproducing without the concept, is also making derivative works. If this connects to what we have discussed about software already. What is not an infringement of copyright, which again can be relevant for software, but in general for many things. If you only use a small portion called in the legislation insubstantial parts, it's okay. So you can use a small routine of a software from another software without infringing anything if it's small enough. How much is enough? It's of course is a matter of debate, and only a judge will tell you. But if you're reasonably convinced that it's small enough, you can maybe use it. You can use it for research or study, criticism or review, reporting of news, and giving professional advice. So this is called fair dealing. If you're using not for commercial use, but for research, study, advice, you can still use a copyrighted material without problem, let's say. Also educational copying, but in this case, you may have to compensate economically the author. So you can use, for example, this slide as long as you acknowledge for educational purpose. You cannot sell them. In that case, You had to ask permission for me, but you can use them to teach a friend, for example, without problem. But you had to inform me anyway, but you're not doing something illegal. If you sell them, you're doing something illegal. You can use, in the case, okay, software does not apply, but in the case of books, you can do public readings or performances at home. In this case, maybe software can kind of be related. I'm not totally sure about that. And of course, works copy that are in libraries, public libraries. Oh, now we come to database right. Database right, copyright protection extends to databases and other compilation of entries if they are creative enough, if they are creation of the mind. In which sense? The single entries of the database, of course, are not original. Usually you create a database of entities that are already there. But if the way you select and arrange the entries of the database is original, then you can claim copyright for that selection and arrangement. So for the database in its entirety, even though the single entries are not protected, they cannot be protected because they're already there. Unfortunately, this is not everywhere, but in the European Union, it is protected, not in the US, for example. So in the European Union, you can also protect your database as it is. This is because it's not just original and creative. It also takes a lot of time and effort to compile and verify a database. So to protect this substantial investment, even if it's not that creative, the European Union gives you the right, the database right. Database right is distinct from copyright. It's a derivation, but it's distinct. So if the arrangement, selection, and presentation is original and creative, it also can be protected with copyright, with standard copyright. If it's not original, but since you can demonstrate that you put a lot of effort in developing the database, it can be protected in the European Union and United Kingdom with database right. So you can get two types of protection. One is for only Europe, but for any type of database which is big enough that you can claim you put a lot of effort into it. And then if it's also original, the way you select it, you can also claim this everywhere in the world, also copyright, standard copyright. Another important point is that database rights are automatic, so do not have to be registered, although if you register it is better because you can, then the infringer cannot claim he didn't know. It lasts only 15 years, so less than other type of protection or copyright itself, but still 15 years in business are quite enough for databases. Also because anytime you update the database in a substantial way, you can reclaim protection for other 15 years. And this protects you also from reverse engineering. You know what reverse engineering is, I guess? So if someone do not have access to database, but by studying what your database used to, can reconstruct piece by piece what are the entries of your database. If you can demonstrate that they have done this process, so they have copied, although with this reverse engineering, your database, you can still claim that they are infringing your rights. Okay, it's almost 11, so I have quite a lot of slides. We can continue tomorrow, of course, but if you don't mind, I will go on at least until 11:15, hoping that, of course, you are interested in the because I don't want to compromise too much tomorrow's schedule, because tomorrow I'll show you a lot of real case example. So unless you stop me from the chat or from I would go on for another 15 minutes if you don't mind, and then of course I'll answer your questions. So trade secrets, strangely enough, if you don't want to patent, copyright, whatever, but you think because by disclosing you will lose your competitive advantage, you can always claim that it's a trade secret, and so get some protection out of it. Not as much as you, because it's more difficult to demonstrate, more difficult to enforce, but you can still try to have protection by something that you wanted to keep secret, as long as it gives you an advantage. This is very useful in markets where the obsolescence of solutions, technical solutions, is very fast, like ICT. In ICT, getting a patent will take a year and a half and will only protect you afterwards, and you still are disclosing, or 2 years, and you're still disclosing the way you're doing things. So sometimes in ICT, it's better not to disclose at all and to claim it to be a trade secret. Of course, with product, this is very difficult because then the mobile phone is on the market, so everyone can see it. So in that case, it's definitely better to have the patents. But for processes, it might be useful not to tell how you do that things. But then how do you protect yourself? How you try to enforce this protection? Because the law guarantees you, but then it's not easy because you have to demonstrate that there's something specific that you wanted to keep secret. So there are ways to do it, to try to do it. The first one is to let everyone involved sign a non-disclosure agreement, which is basically a document that they sign telling you that if they know the secret, you want to keep secret, they don't have to tell you because otherwise it's not a secret. This gives you some legal way of going to court saying, oh, you violated the non-disclosure agreement. This can be done with your employees, but mainly with third parties that can become in touch with your solution before it goes to the market. Another way is to put reserved confidential everywhere in all documents. Again, in this way, if someone comes to them, he cannot claim, or he or she cannot claim that he didn't know it was a trade secret. In that way, you can try to protect even the things that you haven't protected with the patent, with the copyright, or whatever. Now let's come to the last. I left patent for the last because it's on one hand is a more sophisticated, let's say that's more complex, and the other is we already spoke about patent in the beginning. So what is a patent? Again, there might be misconception, or if you ask the man in the street, they think, okay, it's an invention. No, the patent protects the invention, but it's not the invention. The patent is a contract, is a document, as all of the other IPRs are. Actually, this is true anyway, but it's particularly valid for a patent because a copyright, it's automatic. You don't have a contract in your hand. A trademark, you register a logo, but then that's it. So you're protected, but you don't have a contract in your hand. The patent itself is a contract between the inventor and the state. So it's a legal, from the legal point of view, it's a contract between the inventor and the state. The inventor gets the protection for a limited time, it's 20 years, and they have the exclusive rights to produce, use, and sell. Why the state accord this protection? Because the inventor, to boost the economic system. The interest of the state is to boost economy, to boost the innovation system of the country. And so the people who invent something need to have some reward for their efforts. And they have to be some exclusivity in the market, otherwise they will be eaten by the bigger players. But then this protection is not endless, because since the state wants to, for the economy of the country to improve, it cannot block innovation because patents, so the patents only for a limited amount of time. Then has to be public, because other people want to know that the technical knowledge has advanced. They want to avoid reinventing the wheel, as we said in the first slide. And then they want to ensure a fair competition. So when the right has expired, other people can take the same things and improve it and make it better. So that's why the contract has a limitation in time, in coverage, and in applicability. You cannot, there are things you cannot patent because of this contractual nature, because the interest of the state that gives you these rights is not to protect you, but is to improve the country economy. So there are things you cannot patent. What are the rights? Well, again, exclusivity, no one can use, sell, or import, but it only applies in your nation, in the nation you have filed. This is very important. A patent protects you, as many of the also copyright applies in, no, sorry, copyright is not true because it's automatic, but the things that you have to register, like patents, also only in the country where you file the registration. So if you file a patent in Europe, it does not protect you in the United States, and vice versa, or in China, and vice versa. So you have to file a patent in each country you want to get the protection in. And it's timed, so in 20 years it will expire. It's transferable, as not all contracts are transferable, not all the rights given by contract are transferable. You can sell or license your patents to others. This is very important for the economy and for you if you are willing to sell. be also aware that even if you're right for your invention, not necessarily you can produce things out of it, because the product can have some technical details that is in infringement or someone else's patents. So having a patent in itself is not enough. I'll show you in a minute what you need to do to go into the market really. Now, to come to what can be patented, and there was also a question at the beginning about how much different solution should be to avoid the patent infringement. No? Okay, first of all, it has to be a solution or a specific problem in the field of technology. It cannot be, for example, solution to the problem, to the meaning of life. It has to be a specific problem in the field of technology, so which is also said suitable for industrial application. Okay, it has to be new, so it has to, didn't have to appear anywhere else before. So if you publish a paper before a patent, it is not new and you cannot patent it anymore. It has to be inventive or non-obvious, which means, we'll see in a slide but when I answer, remember when I answered the first question, does not have to be a natural consequence of the prior art for a person that is skilled in the art. So let's go back point by point. New at the date of filing of the patent application. So before that, after that, it can appear anywhere, but before you file the patent to the patent office, doesn't have to be appear anywhere else in the state of the art, which means everything made available to public. I remembered you that, for example, Star Trek episode with the tablet was used in a court, so that even if the product was not there, was just an invention in science fiction, it was already available to the public, the concept. It can be oral. If you speak at a conference about your invention and someone recorded, so there is proof that you spoke about that, you cannot patent it because it's public, even if it's oral and not written, and so on. So be very aware of self-made prior art. So you talk publicly or publish about the invention. In that case, you made prior art for yourself. The most tricky point is the inventive step. The definition is that an inventive step is something that is not obvious to a person skilled in the art. A person skilled in the art itself is tricky. So it's someone which is not particularly creative, but knows his stuff in the sector. So it can be a mechanic for an auto, for a car, can be a computer programmer, not particularly skilled, but normal computer programmer in the ICT and so on. And then what is not obvious? So it has to be an invention that implies something that doesn't not follow plainly or logically from prior art from the expert of the field. So the mechanic say knows how to fix car. If the patent is about a way of fixing car that maybe is new, but the mechanic could have done it itself just as a natural logical consequences of the way of fixing cars, the existing way of fixing car, this is not inventive. Of course, this is still kind of vague. So the examiners, the patent office are in charge. They receive a lot of training to be very specific about if something is inventive or not. So when you file a patent, you try to be as inventive as possible, but then there will be a judge of that, which is the examiner, will tell you if it's obvious or not for the person skilled in the art. If you do not agree, you can say, I do not agree. There's a procedure, there's an ITER to say that in your opinion is original, and you can try to have the examiner reconsider your position. It's like a peer review in papers, in scientific peer. The peer review can say, no, this is not to be published. And then you can say, no, I think it is. And you have to give, of course, to provide proof in favor of this. And in the end, you succeed, then you get the patents. If you don't, then the patent is rejected. And that's application, of course, as we've seen, it has to solve a technical problem. The other important thing is that it has to be possible to apply it. You're not forced to apply it. So as long as it's possible to realize it, for example, you can't patent perpetual motion because it's impossible to realize, but you don't have to produce it. So this reconnects to one of the use of patents to block others. You may want to produce only the one that is most, for example, cheapest. to produce. But you want to patent all the other variants in any case, even if you're not producing them for real, because you want to block anyone else. But you can still get a patent out of it because the possibility is what is important, is not the fact that you're really producing them. I mentioned that alongside patents, there's also utility models. Utility models is a kind of patents where the inventive step, the most difficult one, by the way, to demonstrate, it's not requested. It has to be useful, applicable, and new. So utility model, which are in many jurisdictions, but again, not in the United States, but for example, they are in Europe, they are valid. It's a way to protect your things when it's not innovative enough, inventive enough to get a patent. When the innovation, so is only incremental and not substantial, and it's also cheaper and quicker to, if easier to get. So consider, at least in Europe, utility model as a valid alternative to patents when you do not, to get a protection, to get an intangible asset for your company, for your business, when the patent itself cannot be achieved. Of course, patents will be better, but if it's not inventive enough, because in incremental innovation, you can still apply for a utility model. So you can get maybe a main patent for the main innovation, and then each incremental things that will be obvious for the practitioner and the other, so we cannot be patented, can be still protected with the utility model. So your portfolio can include a patent, a couple of utility models, a trademark, which distinguishes it from the others, a copyright of the software, and maybe, so you create a portfolio of intangible assets. By the way, this is not the topic of today's talk, about many countries have also tax deductions for, or other kind of incentives for patent portfolios. So also the cost of producing that, it will be decreased a lot by taking advantage of these incentives. But this is country by country, so we don't go into that. IPR rights covers almost any creation of the human mind, but there are things that cannot be patented because they will prevent, either they are immoral to be patented, they will prevent the development of economy. So scientific discoveries cannot be patented. Aesthetic creation can be copyrighted but not patented. And here it comes the most relevant for probably for today's audience is this methods for performing mental arts, playing games, doing business, and programs from computer cannot be patented as such. We'll see that there is a way around it. So even business methodology cannot be patented in Europe, but they can be patented in the United States, for example. So method for doing business in fintech is not patentable as a method in Europe, or it is in the US. You have to find a different way to rephrase it. And the same from computer programs. We'll see it in the next slide. And of course, things which are against morality or cannot be patented. Plant or animal varieties or essential biological process cannot be patented. And of course, this is for ethical reason, methods for treat human people and diagnostic method. So you cannot patent a life-saving surgical methodology, for example, because that would be unethical and will create suffering. Let's go to software. Okay, as such, in the European Union, software is not patentable. What we mean by as such? By the way, in the US, it is patentable as such, but the European Union is not. As such, meaning that does not have any technical effect. So if it has a technical effect, you can patent the technical effect. If it's only a software that runs on a computer, it does nothing rather than running, you cannot patent it. Let's make this clear with two real examples. A program for controlling an X-ray apparatus having instruction adapted to carry out the following step. Step 1, step 2, and step n. Further effect generated by the program running on a computer is to control the X-ray apparatus. Okay, so as long as the computer is only running steps, the software is only running a series of steps, like for example, calculating the intensity of radiation that has to be, this is not patentable per se. But because it has a technical effect which is controlling the X-ray apparatus that then physically emits radiation, this is a technical effect. And so this software can be patented because of the technical aspect. So a software that does that gives command to something physical, for example, can be patented. a program for checking the spelling of a word having the following instruction 1 to n, and the factor effect generated by the program running on computer is the decision of orthographic correctness, so basically the orthographic corrector of Word or other text editor, it only runs on the computer or on the screen, so it does not have any technical effect. There is an effect on the user, but it's not technical. So this is cannot be patented in the European Union. So depending on what is the nature of your software, sometimes you have a way of formulating things and that you can protect it with a patent. In other ways, if it's only, for example, if it's a game software for Minecraft or other games, you cannot patent it in Europe because the only effect is on the screen. There's no physical, no technical effect. But all the software that, for example, controls machines can be patented. So again, the invention must be a technical character. Technical features are physical parameters or control parameters or processes, devices, machines, and so on, or the physical features of an entity. For example, if your software controls the memory of your computer, which is a physical part of the computer, or the port, and so it's not just displaying information, but is acting on physical components of the hardware, then again, it's a technical effect. What are non-technical features are, for example, at least for the European Union, for example, method steps of a mental act, can be a game, or method steps of a business or financial process. For example, software for business or for fintech or Excel cannot be patented. In that case, it's always advisable to file for copyright. How you do that, even though copyright in principle is automatic, it's much better to handing a copy of the program on a magnetic support, I guess nowadays also on a solid device, so on any kind of support, at the dedicated national agencies. Okay. Last concept for today. I told you that even if you get a patent, not necessarily you can produce something, because in some aspect of the cause which are not related to your patents might be protected by someone else's patent, and you're not aware of it. So the infringement occurs when the invention is used, produced, or imported. If you only get this is also important. If you get a patent which is similar to someone else, you're not infringing because you're not producing. You are forbidden to produce, but your patents can be there and you don't have to pay anything. It's not, I mean, they can ask you to withdraw your patents. This can happen, but they cannot tell you, since you're not producing things, you cannot tell you have to pay anything. Because there's no infringement. There's only an invalid patent. The patent can be withdrawn because it's invalid. They shouldn't be in there because it's not new, basically. But as long as you don't produce it, it's not a legal trouble for you. Another important thing to be aware is that are those two. If it's not in the part that is called claim, it's in the title, it's not protected. And the other thing is that it has to be enforced in the country because it's a contract with the state. So if you are afraid that the people will copy you in China or in Italy or in United Kingdom, in Sweden, you have to file a patent there. Otherwise, it doesn't matter that you have a patent in France or in Germany, because the infringement occurs in the country, in the other country. And finally, as I said, having a patent does not apply automatically to the whole product. So to produce a product, you have to be sure that you do not infringe any aspect of the product, do not infringe any valid patent. In that case, it's called, you have the freedom to operate, so to produce the product. In Europe, this is just a concept. In the United States, for example, it is a document on its own that you have to produce before going to the market. So in certain jurisdictions, you also have not just have to be aware that you do not have any patent infringing, but you also have to produce a demonstration of it because you've done your research and you produce this document, which is called freedom to operate. Just to conclude, okay, I show you the first example of the Vespa. Let's make a guess. How many intellectual property rights do you think there is in an ordinary smartphone? Okay, unfortunately, you don't have the audio, so I cannot get, but so I'm not even trying to guess if you're going to be right or not, but all of them, basically, any smartphone, as many of the modern devices, are protected by a full range of intellectual properties? 2000s. Okay, this is a good estimate. This is a good estimate. Maybe a bit less in a specific model. For sure, much more in a line of product. For example, all Nokia have many, many thousands of patents. There is a raise the hand, please. There is a hand raised that you can speak, I guess. No. Okay, I keep going, but the person who raised the hand can take the speak whenever he wants. So here, just an example, of course, of the hundreds that are probably in this phone. There are trademarks. There's the producer trademarks Nokia, but also the name of the product, the specific is trademarked, but also the software that runs on it is trademarked, not by Nokia, but the producer of the software, for example, Android, but also Java is a trademark. So the programming language, no? The processor as a trademark of the company producing the processor, like Qualcomm Snapdragon in case of this. Of course, this is not a technical thing. This is a commercial name, so it's a trademark, okay? Then you have copyrights. There's a software code, which we've seen can be copyrighted, but also the instruction manual is a creativity arrangement of things, and it's written form, so it's copyrighted. The ringtones, it's an audio copyrights, but all the ringtones for the, of course, the one that are original for the Nokia phone can all be copyrighted. And each one of them is a different copyright. So it's easy to reach 2000 in this way, right? Of course, there will be probably a lot of technical patents for data processing methods, but also in the component. Not all of them are by Nokia. I'm just saying that there's a lot of IP in the phone. Semiconductor, of course, they are all patented. Any different type of semiconductor is patented, circuit, sorry, in the semiconductor. Actually, might be a patent also on the technology for producing the semiconductor itself, chemical compounds, and so on. Then there is design, the form, the overall shape of the phone, the arrangement of buttons, the shape of the corner, three-dimensional form of the buttons. They are all things that have been covered by design. And this is for sure because, as I told you, Apple and Samsung had a billion trial because of issue related to design, not to the technical patents. And then, of course, there might also be trade secrets. They, of course, we don't know because they are secrets, but for sure there are things in the ICT world, some software, some aspect, some processes will not be known, but they are protected as a trade secret. Okay. I stop now, and I'm sorry if it took more than 2 hours. I hope it was for the best because you enjoyed it. And please ask any question you would like to ask. Yes.
Okay, sorry again. So I have this question about if we publish some papers while we are doing research at the research institute that we are working in, and later on we decide to transfer that technology into a spin-off or startup, then who owns the intellectual property?
Nobody, because you publish the paper. If you publish a paper, you cannot patent it.
But why some people say that you have to pay royalty to the research institute? Well,
okay, why? There are two different things. First of all, you can patent it provided you have not disclosed it enough in the. So in this case, if there is a patent, there is a patent, and then we come to that. The other point is that there are contracts between the researcher and the research institute. So that varies with the contract. So if your research institute is pretty say in the contract when they hired the researcher says any business activity that come out from the research, you have to pay royalties. This is written in the contract. It's not related to the discipline of intellectual property rights. It's an agreement between the researcher and the institution that pays the researcher in the first place. So this one could be one of the explanations. Of course, I don't know because it depends on the specific contract of the specific research institutions, but it's very common. For example, in the university I come from, it's quite common, even if you don't have a patent, but if it's clear that the business you're doing originates for the research for which you were paid by the university or by the Italian state, then you have to give something back. But it's not related to patents or to intellectual property rights, but to the contract that you signed and to the fact that you are using the result of the research that was paid by the institution, by the state. Going back to patents, if you have published something, but you can still file a patent, again, the patent, you are the inventor. I think I didn't want to go into technical details, so I didn't tell you all the aspects of the patents, but one thing has to be clear since of this question, that the inventor and property of the economical rights are not the same thing. There is a thing in the patents which is called assignee, which is the entity that has the economical rights of using the patent. And then there is the inventor who is the one who got the idea. Okay, inventor and assignee can be the same person. If you patent something that you have invented, you also claim the economical rights. Okay, you pay for the patent and it's yours. But if you are in a research institution, there are two things. First, who pays for the patents? If the institution is paying, then he is the owner. It is the owner of the economical rights. And secondly, what are the agreements on intellectual property between you and your institutions? Again, if in your contract is written that any patents that you can file, it's co-owned by, at least in the economical point of view, by you and the institution that paid your research, then even if you have a patent on your name as an inventor and as a co-assignee, you still own some royalties to the institution because of this kind of agreement, and then usually the institution is also co-assignee, not always, depends on the agreement in the document. So I hope that answers your question.
Yes, thank you. Thanks a lot.
You're welcome. Other questions? Okay, if there are no other questions, first of all, of course, I thank you for your attention. If you have other doubts, maybe you can write me. This is my email address. Tomorrow, we'll see real cases. Today was a way also to get into the world of IPRs, what people who are not familiar with. So I had to also to present the various types, and I gave you the general principle why they can be useful for business. And but tomorrow we'll see real cases for the. I remember that tomorrow the lesson is at 10, starts at 10, and that's it. Thank you again, and goodbye. See you tomorrow.